perhaps even more importantly, the importance of passing the word of legislation. Thank you, Mr. Chairman.
The gentleman from New York continues to reserve. The gentleman from Pennsylvania is recognized.
I continue to reserve.
And the gentleman from Pennsylvania continues to reserve. The gentleman from New York is recognized.
Madam Speaker, I'd like to forgive the gentleman from Minnesota for his vulgarity on the House floor. It's hard not to curse when mentioning the title of this motion. It's also hard not to curse when you realize that only 60% of the high-hazard dams have an emergency action plan, and it's one of the reasons this bill is so important. I'd like to yield at this time to my friend, the gentleman from Tennessee, Mr. Cohen, for as much time as he should consume.
Gentleman from Tennessee is recognized.
Thank you, Madam Speaker, and I want to thank Mr. Maloney for his work and Mr. Schuster for his work. And we damn well better get prepared to increase our infrastructure spending, or we'll have more problems in this country. The motion to instruct conferees is well taken and well drafted. Our roads, rivers, railways, and runways got a D+ on the American Society of Engineers 2013 report card for America's infrastructure. That's inexcusable. A D+ on our infrastructure. We used to be the pride of our country, and one of the ways that we produce jobs and took goods to market. The fact that this Corps was awarded to a world superpower and a leader in technological innovation is completely unacceptable. Passing word is an important step towards turning around our nation's infrastructure investment program. It's proud to work with and support our outstanding Chairman Schuster, and Ranking Member Rahal when we passed the bill in both the Transportation Committee and on the House floor. Our committee understands, I think not totally, I can't speak for the whole committee, but in general, that earmarks aren't a bad thing, and earmarks are something that greases the wheels that makes the engine of government run and work effectively and bipartisanly. And we need to bring those back to make this House work together, Democrats and Republicans, so we all have something invested for our districts. That's important. People ask about dysfunction here, and people not working together is because everybody doesn't have some part of the pie, something for their districts that they can be proud of, and we need to get that back, and people need to understand that Article 1 says this Congress is supposed to appropriate the monies. And that's why our infrastructure is weakened, and that's why we have so many projects along rivers where the Corps of Engineers don't have adequate funding and direction to keep our rivers moving and moving commerce forward. WRDA doesn't mean that not just about our nation's waterways, locks, and dams will be the subject of targeted investments, which it needs to be. It means that thousands of people will be put to work on making the improvements necessary to improve the national infrastructure. The effect of sequestration on our nation's infrastructures are real, and it's time to get back on track towards smart investments that make our nation more competitive in the global marketplace. The Corps of Engineers has a backlog of authorized projects in excess of $60 billion. The Corps construction account has been reduced by $688 million since 2010. We should be doing more to build that infrastructure and create jobs, not less. According to a study by the American Society of Civil Engineers, if we don't make new investments in our new water infrastructure, we'll lose $416 billion in GDP by 2020 due to increased cost and loss of worker productivity. This means real loss for real American families. Madam Speaker, I think in Turkey they're probably improving their infrastructure. We should be doing the same thing here in America, Madam Speaker. It's important that we do that. Without investment, the average American family would have to adjust their household income to account for a $900 squeeze as a result of rising water rates and falling personal incomes. The longer we put off investment in our nation's infrastructure, the more that investment will cost, and the more people will be out of work, and the more difficult it will be for our economy to get righted. So I support this motion to instruct conferees today. I thank Mr. Maloney and Mr. Schuster, and hopefully we can put America's infrastructure investments back on the right track. But to do that in the long run, we need bipartisanship, which will involve earmarks in making the transportation bills like they used to be when Mr. Schuster's father was there and like Mr. Schuster would like to make them. If we could just take Mr. Schuster and clone him, we could work together and have a greater America and more jobs and a greater country. Thank you very much. I'll reel back the balance of my time.
The gentleman from New York reserves. The gentleman from Pennsylvania is recognized.
I continue to reserve. First of all, inquire, do you have other speakers? Are you prepared?
Mr. Chairman, I'm prepared to close if you'd like to.
Well, then I'll finish up mine. Again, we expect to continue to work with the Senate on this language. It's a critical program. It saves lives, protects communities, and so again, we accept the motion to instruct. And with that, I yield back the balance of my time.
The gentleman from Pennsylvania yields back. The gentleman from New York is recognized.
Madam Speaker, and I'd like to thank again the Chairman, Mr. Schuster. As frustrating as Washington can be, for many of us who are new to the Congress, we can actually get results, make a difference by conferencing the Water Resources Reform and Development Act. We have the opportunity for the Congress to set aside petty politics and partisanship to actually get something done for the American people. WRDA is a critical and strategic investment in our nation's aging infrastructure and creates jobs, strengthens our local economy, and keeps families all across the country safe. We can make it even better by ensuring that every state and community has the resources to conduct safety inspections and to create emergency action plans. And again, there are 14,000 high-hazard dams in this country, only 60% of which have an emergency action plan. This program makes sense. And don't take it from me, you can take it from the folks in Warwick, New York, where one of these high-hazard dams exists. After experiencing nearly a foot of rain in 24 hours, many families were forced to evacuate for fear of a potential series of dam failures and catastrophic flooding. Warwick had a plan in place, though, and conducted a safe evacuation. Dams like those in Warwick rely on the National Dam Safety Program to enhance the safety of their dams by hiring staff to conduct inspections, to purchase equipment, and develop emergency action plans for dam safety. These plans save lives and prevent catastrophe. Investing in the National Dam Safety Program provides our communities with the resources they need to protect our families and our economy by conducting safety inspections and creating plans. It's simply put that a stitch in time saves 9. Nowhere is that more true here, and I hope we can join together in a bipartisan way to support communities all across America by passing this motion to make the final version of this bill even better. Thank you, Madam Speaker, and I yield back.
The gentleman yields back. All time for debate has expired. Without objection, the previous question is ordered. The question is on the motion to instruct. Those in favor say aye. Aye. Those opposed say no. In the opinion of the Chair, the ayes have it.
Madam Speaker, I request the yeas and nays.
The yeas and nays are requested. Those favoring a vote by the yeas and nays will rise. A sufficient number having risen, the yeas and nays are ordered. Pursuant to Clause 8 of Rule 20, further proceedings on this question will be postponed. For what purpose does the gentleman from Virginia seek recognition?
Madam Speaker, pursuant to House Resolution 403, I call up H.R. 2655, the Lawsuit Abuse Reduction Act of 2013, and ask for its immediate consideration.
The clerk will report the title of the bill.
Union Calendar Number 181, H.R. 2655, a bill to amend Rule 11 of the Federal Rules of Civil Procedure to improve attorney accountability and for other purposes.
Pursuant to House Resolution 403, the bill is considered read. The gentleman from Virginia, Mr. Goodlatte, and the gentleman from Michigan, Mr. Conyers, each will control 30 minutes. The Chair recognizes the gentleman from Virginia, Mr. Goodlatte.
Madam Speaker, I ask unanimous consent that all members may have 5 legislative days within which to revise and extend their remarks and include extraneous materials on H.R. 2655 currently under consideration.
Without objection.
Madam Speaker, I recognize myself for such time as I may consume.
The gentleman from Virginia is recognized for such time as he may consume.
Madam Speaker, H.R. 2655, the Lawsuit Abuse Reduction Act, would restore mandatory sanctions for frivolous lawsuits filed in federal court. Many Americans may not realize it, but today, under what is called Rule 11 of the Federal Rules of Civil Procedure, there is no requirement that those who file frivolous lawsuits pay for the unjustified legal costs they impose on their victims. As a result, the current Rule 11 goes largely unenforced. When there is no guarantee of compensation, the victims of frivolous lawsuits have little incentive to spend even more money to pursue additional litigation to have the case declared frivolous. H.R. 2655 would finally provide light at the end of the tunnel for the victims of frivolous lawsuits by requiring sanctions against those who file them. Sanctions that include paying their victims the full cost of their reasonable expenses incurred as a direct result of the Rule 11 violation, including attorney's fees. The bill also strikes the current provision in Rule 11 that allows lawyers to avoid sanctions by making frivolous claims and demands by simply withdrawing them within 21 days. This change eliminates the free pass lawyers now have to file frivolous lawsuits in federal court. To be clear, under Rule 11, a lawsuit is frivolous if it is presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation if it is not warranted by existing law, or if the factual contentions have no evidentiary support. In other words, a lawsuit will only be found frivolous if it has no basis in law or fact. Yet, the current lack of mandatory sanctions leads to the regular filing of lawsuits that are clearly baseless. For example, in just the last year, a small business owner was sued for violations of federal regulations in a parking lot that he doesn't own or lease. A woman had her car repossessed and then filed a $5 million federal lawsuit for the half tank of gas she had left in the car. A high school teacher sued a school district claiming it discriminated against her because she has a phobia, a fear of young children. Her case was dismissed by the Equal Employment Opportunity Commission, but that didn't prevent her from filing a federal lawsuit. These real, yet absurd cases have real-life consequences for their victims who have to shell out thousands of dollars just to respond to frivolous pleadings, endure sleepless nights, and spend time away from their family, work, and customers. Let's not forget that the victims of frivolous lawsuits are real victims. Do any of my colleagues on the other side of the aisle claim that judges should have the discretion to deny damage awards to victims of legal wrongs proved in court? If not, why should judges have the discretion to deny damage awards to victims of frivolous lawsuits who prove in court that the case against them was frivolous? It is difficult to see how a vote against the bill before us today could be interpreted as anything other than a denial of that victims of frivolous lawsuits are indeed real victims. But indeed they are real victims, and they deserve to be guaranteed compensation when they prove the claims against them are frivolous in court. Let's also remember that the victims of lawsuit abuse are not just those who are actually sued. Rather, we all suffer under a system in which innocent Americans everywhere live under the constant fear of a potentially bankrupting frivolous lawsuit. As the former chairman of the Home Depot Company has written, an unpredictable legal system casts a shadow over every plan and investment. It is devastating for startups. The cost of even one ill-timed abusive lawsuit can bankrupt a growing company and cost hundreds of jobs. The prevalence of frivolous lawsuits is reflected in the absurd warning labels companies must place on their products to limit their liability. A 5-inch brass fishing lure with 3 hooks is labeled harmful if swallowed. A vanishing fabric marker with disappearing ink warns it should not be used as a writing instrument for signing checks or any legal documents. A label on a scooter says, warning, this product moves when used. A household iron contains a warning, never iron clothes while they are being worn. And a cardboard car sun shield that keeps sun off the dashboard warns, do not drive with sunshade up. the potential for frivolous lawsuits are behind all these absurd warning labels, which, while humorous in their own way, serve as a warning to us about what the world will increasingly look like if we don't make the rules more fair. Today, absurd lawsuits can sometimes bring sanctions against those who filed them. But even when they do, the current rules result in far too little compensation for the victims of the frivolous lawsuit. In his 2011 State of the Union address, President Obama said, and quote, "I'm willing to look at other ideas to rein in frivolous lawsuits." Well, I hope the President has time to read this one-page bill and lend his support to a proposal that would significantly reduce the burden of frivolous litigation on innocent Americans. And I thank the former chairman of the House Judiciary Committee, Congressman Lamar Smith, for introducing this simple, common-sense legislation that would do so much to prevent lawsuit abuse and restore Americans' confidence in the legal system and reserve the balance of my time.
The gentleman from Virginia reserves. The gentleman from Michigan is recognized.
Thank you, Madam Speaker. I yield myself as much time as I may consume.
The gentleman's recognized.
I rise in opposition to H.R. 2655, and I suggest that what we're doing here this afternoon will turn the clock back to a time when federal rules of civil procedure discouraged civil rights cases, limited judicial discretion, and permitted satellite litigation to run wild. I repeat, we may turn the clock back to a time when the rules of civil procedure discouraged civil rights cases, limited judicial discretion, and permitted satellite litigation to run wild. And here's how it accomplishes it, by undoing the 1993 amendments to Rule 11 of the Federal Civil Procedure, by 1, restricting judicial discretion, 2, requiring mandatory sanctions for even unintentional violations, and 3, eliminating the current rule's 21-day safe harbor provision, which has been so beneficial to our federal court system. And so, to put it as simply as possible, H.R. 2655 will have a disastrous impact on the administration of justice. Now, how would this chill legitimate civil rights litigation? Civil rights cases often concern novel issues which made them particularly susceptible to Rule 11 before the 1993 amendments. I hope all the members of this body appreciate how significant this is and the important history that was made during that earlier period of time. For example, 1991 Federal Judicial Center study found that the incidence of Rule 11 motions were higher in civil rights cases, than in some other types of cases. Another study showed that while civil rights cases comprised about 11% of federal cases filed, more than 22% of the cases in which sanctions had been imposed were civil rights cases. This legislation will substantially increase the amount, the cost, and intensity of civil litigation and create more grounds for unnecessary delay and harassment in the courtroom. Experts in civil procedure are virtually unanimous on this point. By allowing Rule 11 to be used as a tool to impose court costs on the other side, The 1983 version spawned a virtual cottage industry of Rule 11 litigation. Each party had a financial incentive to tie up the other in Rule 11 proceedings. Professor Theodore Eisenberg of Cornell University has demonstrated that roughly 1/3 of all federal lawsuits were burdened by this, quote, satellite litigation, unquote. During the period when this prior version of the rule was in effect, and attorneys had a double duty, he argued, one to try the case and the other to try the opposing counsel. In recognition of these problems, the Judicial Conference amended the rule in 1993 to its present form. And so we should realize that we have the support and have appreciated the constructive assistance of many of these organizations. The American Bar Association, the Alliance for Justice, the Consumer Federation of America, the National Consumer Law Center, the National Consumers League, Public Citizens, the United States Public Interest Research Group, among others. And so in addition, the legislation is opposed by the Judicial Conference of the United States, the principal policy-making body for the judicial branch, charged with proposing amendments to the Federal Rules of Civil Procedure under careful, deliberate process outlined in the Rules Enabling Act. Madam Speaker, I reserve the balance of my time. Thank you.
The gentleman from Michigan reserves. The gentleman from Virginia is recognized.
Madam Speaker, at this time it's my pleasure to yield 5 minutes to the gentleman from Arizona, Mr. Franks, the chairman of the Subcommittee on Constitution and Civil Justice.
The gentleman from Arizona is recognized for 5 minutes.
Thank you, Madam Speaker, and I thank the chairman. I also want to express my appreciation to Chairman Goodlatte and Chairman Smith for both introducing and bringing forth this simple but important and much-needed legislation. Madam Speaker, in order to stop lawsuit abuse, promote jobs in the economy, and restore basic fairness to our civil justice system, Rule 11 of the Federal Rules of Civil Procedure must be amended. Rule 11 provides for one of the most basic requirements for litigation in federal court, that papers filed with a federal district court must be based on both the facts and the law. In other words, Rule 11 imposes on attorneys the very modest obligation to undertake a reasonable investigation of the facts and the law underlying a claim before filing it. This is a simple requirement, Madam Speaker, but one that both sides to a lawsuit must abide by if we are to have a properly functioning federal court system. Unfortunately, the current version of Rule 11 permits attorneys to file a lawsuit first and then try to back up their claims with law and the facts later. This is because under the current rules, failure to comply with Rule 11 does not necessarily result in the imposition of sanctions. The fact that litigants can violate Rule 11 without penalty significantly reduces the deterrent effect of Rule 11, which harms the integrity of the federal courts and leads to both plaintiffs and defendants being forced to respond to frivolous claims and arguments. The Lawsuit Abuse Reduction Act corrects this flaw, Madam Speaker, by requiring that federal district court judges impose sanctions when Rule 11 is violated. Mandatory sanctions will more strongly discourage litigants from knowingly making frivolous claims in federal court. It will also relieve litigants from the financial burden of having to respond to frivolous claims, as the legislation requires those who violate Rule 11 to reimburse the opposing party for reasonable expenses incurred as a direct result of that violation. Additionally, the legislation eliminates Rule 11's 21-day safe harbor, which currently gives litigants a free pass to make frivolous claims so long as they withdraw those claims if the opposing side objects. According to the Federal Rules of Civil Procedure, the goal of the rules is to ensure that every action and proceeding in federal court be determined in a, quote, just, speedy, and inexpensive, unquote, manner. Mr. Speaker, Madam Speaker, I believe that this goal is best served through mandatory sanctions for violating this simple requirement of Rule 11, that every filing be based on both the law and the facts. So I would just urge my colleagues to support the Lawsuit Abuse Reduction Act to restore mandatory sanctions to Rule 11. And with that, I would yield back the balance of my time.
The gentleman from Virginia reserves. The gentleman from Michigan is recognized.
Madam Speaker, I am pleased now to yield to a senior member of the House Judiciary Committee, the distinguished gentleman from New York, Jerry Nadler, for as much time as he may consume.
The gentleman from New York is recognized.
Madam Speaker, I rise today in opposition to H.R. 2655, the so-called Lawsuit Abuse Reduction Act. Unfortunately, rather than reduce abusive litigation, this bill will have just the opposite effect. We don't need to speculate about the disastrous effect of this legislation because we know from experience just what a fiasco it will be. The rule this litigation would restore was in effect from 1983 until 1993. It was a disaster. After a decade with this rule, the Judicial Conference, the rulemaking body for the federal judiciary, rightly rejected it in favor of the rule we have today. In fact, this legislation goes even beyond the text of the 1983 rule, broadening the flawed mandatory sanctions even further. Worse still, the Judiciary Committee has not made even the pretense of considering this very radical change in civil procedure with any care. In fact, no hearings have been held on this legislation in this Congress. The process or lack of it demonstrates the wisdom of the Rules Enabling Act, in which Congress gave the Judicial Conference the responsibility for reviewing court rules and proposing changes. They have done this job admirably, expending years of careful study to existing rules, to how they are functioning, and the implications of any proposed changes. While the sponsor has expressed the desire to limit unnecessary litigation, the experience with the old Rule 11, which this bill would restore, was the exact opposite. Rule 11 litigation became a routine part of civil litigation, affecting 1/3 of all cases. Rather than serving as a disincentive, the old Rule 11 actually made the system even more litigious and more costly. In the decade following the 1983 amendments, which this bill would restore, there were almost 7,000 reported Rule 11 cases, becoming part of approximately 1/3 of all federal lawsuits. Many civil cases, 1/3, became two cases, one case on the merits and the other on dueling Rule 11 complaints. Madam Speaker, it is rare in life that you get a controlled scientific experiment. But we had one here from 1983 to 1993. We saw the results. They were disastrous. And only incautious people tried to repeat disastrous scientific experiments. The drain on the courts and the parties' resources caused the Judicial Conference to revisit the rule and to adopt the changes that this bill would undo. In a July 23, 2013 letter to Chairman Goodlatte and Ranking Member Conyers, Judge Jeffrey Sutton of the United States Court of Appeals for the Sixth Circuit and Chair of the Committee on Rules of Practice and Procedure, and Judge David Campbell of the U.S. District Court for the District of Arizona, Chair of the Advisory Committee on Civil Rules, said, and I quote, "Experienced research and thoughtful deliberation have shown that there is no need to reinstate the 1983 version of Rule 11 that proved contentious and costly to litigants and diverted so much time and energy of the bar and bench. Doing so would add to, not improve, the problems of cost and delay that we are working to address. We urge you on behalf of the Rules Committee to not adopt the proposed legislation amending Rule 11. I might add that in committee, the majority quoted a survey of judges from 1993 saying that we shouldn't change the rules then. But today, the judges are very glad we changed the rule because they've lived under both systems. Mr. Speaker, Madam Speaker, in addition to all these rules about all these considerations of cost, the bill would hinder the evolution of the common law. One way the common law evolves is by people making claims in court, especially in civil rights cases. Civil rights cases often involve an argument for the extension, modification, or reversal of existing law or the establishment of a new law. and often have relied upon novel legal theories that are particularly susceptible to someone claiming that they are abusive or frivolous. Had the provisions of this bill been in place at the time, they could have discouraged a number of landmark civil rights cases, including Brown versus Board of Education of Topeka, and they could prevent new cases from ever being considered. Perhaps that is why all the civil rights groups, all the consumer rights groups, oppose this bill. Madam Speaker, the courts have ample authority to sanction conduct that undermines the integrity of our legal system. But this legislation is the wrong solution in search of a problem. By taking us back to a time when Rule 11 actually promoted routine, costly, and unnecessary litigation, this bill is a cure worse than the disease. We know what this rule does, and the courts rightly rejected it 20 years ago. We should benefit from that experience, not repeat the scientific experiment, and reject this legislation. I thank you. I yield back the balance of my time.
The gentleman from Michigan reserves. The gentleman from Virginia is recognized.
Madam Speaker, at this time it is my pleasure to yield 5 minutes to the former chairman of the House Judiciary Committee and the chief sponsor of this legislation, the gentleman from Texas, Mr. Smith.
The gentleman from Texas is recognized for 5 minutes.
Madam Speaker, I want to thank Chairman Goodlatte for yielding me time and for also bringing the bill to the House floor today and for all of his hard work on this legislation. The Lawsuit Abuse Reduction Act, known as LARA, is only 1.5 pages long, but it would prevent the filing of hundreds of thousands of pages of frivolous lawsuits in federal courts. For example, in recent years, frivolous lawsuits have been filed against the Weather Channel for failing to accurately predict storms, against television shows people claimed were too scary, and against fast food companies because inactive children gain weight. Frivolous lawsuits have become too common in our society. Lawyers who bring these cases have everything to gain and nothing to lose under current rules, which permit plaintiffs' lawyers to file frivolous suits no matter how absurd the claims with no penalty whatsoever. Meanwhile, defendants are faced with years of litigation and substantial attorneys' fees. These cases, and many like them, have wrongly cost innocent individuals and business owners their reputations and their hard-earned dollars. According to the research firm Towers Perrin, the annual direct cost of American tort litigation now exceeds $260 billion a year, or over $850 per person in America. Before 1993, it was mandatory for judges to impose sanctions, such as orders to pay for the other side's legal expenses when lawyers file frivolous lawsuits. Then the Civil Rules Advisory Committee, an obscure branch of the courts, made penalties optional. This needs to be reversed by Congress. As Chairman Goodlatte noted, even President Obama has expressed a willingness to limit frivolous lawsuits. If the President is serious about stopping these meritless claims, he will support mandatory sanctions for frivolous lawsuits to avoid making frivolous promises. LARA requires lawyers who file frivolous lawsuits to pay the attorney's fees and court costs of innocent defendants. Further, LARA expressly provides that no changes, quote, shall be construed to bar or impede the assertion or development of new claims, defenses, or remedies under federal, state, or local laws, including civil rights laws, or under the Constitution of the United States, end quote. So civil rights law would not be affected in any way by LARA. Opponents often argue that reinstating mandatory sanctions for frivolous lawsuits impedes judicial discretion, but this is not true. Under LARA, judges retain the discretion to determine whether or not a claim is frivolous. If a judge determines at their discretion that a claim is frivolous, they must award sanctions. This ensures that victims of frivolous lawsuits obtain compensation, but the decision to find a claim frivolous remains with the judge. LARA applies to both plaintiffs and defendants. It applies to cases brought by individuals as well as by businesses, including businesses' claims filed to harass competitors and illicitly gain market share. The American people are looking for solutions to obvious problems with lawsuit abuse. LARA restores accountability to our legal system by reinstating mandatory sanctions for attorneys who file frivolous lawsuits. Though it will not stop all lawsuit abuse, LARA encourages attorneys to think twice before filing a frivolous lawsuit. I thank Chairman Goodlatte again for bringing this much-needed legislation to the House floor, and I ask my colleagues who oppose frivolous lawsuits and who want to protect hard-working Americans from false claims to support the Lawsuit Abuse Reduction Act. And Madam Speaker, I want to make one other point, and this goes to the earlier discussion we just had about judicial surveys. 751 federal judges responded to the 1990 survey in which they overwhelmingly supported a Rule 11 with mandatory sanctions. In the 2005 survey, only 278 judges responded, and over half of the judges who responded to the 2005 survey had no experience whatsoever under the stronger Rule 11 because they were appointed to the bench after 1992. So the 2005 survey tells us very little about how judges comparatively view the stronger versus the weaker Rule 11. And, Madam Speaker, I'll yield back the balance of my time.
The gentleman from Virginia reserves. The gentleman from Michigan is recognized.
Thank you, Madam Speaker. I'm pleased now to recognize and yield to the senior active member of the House Judiciary Committee from Houston, Texas, Ms. Sheila Jackson Lee, as much time as she may consume.
The gentlewoman from Texas is recognized.
Let me thank the gentleman for his outstanding leadership of this committee, and let me thank the manager as well, and I thank the Speaker for her courtesies, recognizing this is an important initiative, and so using the time to be able to speak to the members is very important, and I'm glad to have been given the courtesy of being yielded as much time, and I will use it efficiently for this particular legislation. Let me indicate that this is another gift to a large, prosperous, and threatening entities against a single plaintiff. The plaintiff who secures a lawyer who is attempting to create the scales of justice and to balance, if you will, the needs of that individual plaintiff, those small plaintiffs, those collective plaintiffs who are seeking justice. It is a fact that the threat of lawsuits is not a concern of small businesses, as has been represented. A 2008 study indicated by the National Federation of Independent Business that the biggest threats facing them, small businesses, was other concerns, cost, and was not cost and frequency of lawsuits. That was number 65. They need other issues that we should be concerned about. It's a fact that judges support the current version of the rule. And Rule 11 is just one of many tools that judges use. It is not the only tool to be able to be responsive to someone who may be abusing the system. But remember, we're here to perpetuate justice, and justice has scales. And in many instances, that scale is tipped toward the one with the most money, the deepest pockets, the longest time to wear you out as a plaintiff. And let me refresh my colleagues' minds and understanding of the federal system that tort cases are a very small percentage of that civil docket. And so this is not an instance. Many of these cases are filed in the state court. These personal injury cases, these cases dealing with large damages because people have been injured because of bad products and other matters. And so here we have a bill looking for a problem. In actuality, LARA will increase, not decrease, litigation, and you can see the spiking that occurred. The lawsuit abuse reduction would return Rule 11 to the 1993 version. 1983 version. Litigation spiked after the 1983 amendments to the Rule 11. From 1982 to the peak in 1991, satellite litigation increased by more than 10,000%. Here we go with a gift to those who are truly litigious. Just as we've been on the floor of the House pounding the Affordable Care Act because cancellation letters have been sent. They haven't been sent by Republicans. They haven't been sent by Democrats. They haven't been sent by Health and Human Services. They haven't been sent by people who are committed to making sure every American has health insurance. They've been sent by fat cat insurance companies who are sending cancellation letters. Here we go again, the scale of justice imbalanced. Again, the same problem. The mother, the single parent, the family, waiting to get on Affordable Care Act. In the normal course of the process, they get a cancellation letter. What an unnecessary act. That letter could have been, we're modifying your insurance. But there goes the big guys again. You haven't heard one single sound coming out of the mouths of insurance companies to answer the question, why did they send the letters? And here we are on the floor of the House making it even worse. Making it even worse. Under the law regime with mandatory sanctions and no opportunity to correct mistakes, the parties to a lawsuit have every incentive to file Rule 11 complaints and seek court costs and legal fees and to defend against such actions to the bitter end. This is a dynamic that should not happen. We should allow a pullback. We should allow a correction. But all we're doing is just throwing them over the cliff and under the bus. The changes would create a disincentive to abandon or withdraw a pleading or claim that lacked merit and thereby admit error after determining that it no longer was supportable by law or fact. And as I indicated, we have seen this kind since 1983 spike. I have another statistic. Rule 11 cases spiked to 7,000 during the decade following the 1983 rule. And so when a lawyer wants to do right with his client, the little guys, then of course they are blocked from solving the problems. They use horror stories like demand letters, where a lawyer writes a letter demanding compensation in order to get a potential defendant to settle without having to file suit. That's not covered by Rule 11. And as far as I know, that is not an illegal procedure to engage in discussion, to be able to resolve the matter before going to a costly lawsuit. But again, that's the little guy's tool. So you're going to beat up on the little guy, the construction worker that falls because of violations of OSHA rules, or the person that works in a chicken plant who has carpal syndrome because there were no appropriate rest times for them to get off of the line. And you're going to make the argument that this is right for justice. Well, let me just say this, Madam Speaker. This graph speaks for itself. This will add an extra burden of cost to those who are trying to find a way for Lady Justice scales to be balanced. And my belief, under the Sixth Amendment, the right to counsel, and many other aspects of the Bill of Rights, that the Founding Fathers believed that justice should be rendered regardless of your race, color, or creed, regardless of whether you were an indentured servant, regardless of whether or not you came in Pilgrim's Pride or came in some other matter. Rule 11 completely disputes that concept of justice. I'm appalled that we're here at this point today, and it equates to the fat cat insurance companies who have decided to send out letters when they well knew that this was a process that would work ongoing in their modification, that could be noted to those recipients that their insurance was not going away, it was only going to be made better. I'd like to make the justice system better. I thank the gentleman for his time, and I'd like to make sure that the little guy has an opportunity to walk into any court of the United States of America, Mr. Conyers, and stand tall and feel that the judge, no matter what size his pocketbook is, will give him as much credence and respect as the big guys coming in with millions, maybe billions, to make sure he does not or she does not win justice in the court. Today I'd ask our colleagues to vote for fairness for Lady Justice and to vote against this initiative and this legislation. I yield back my time.
The gentleman from Michigan reserved. The gentleman from Virginia is recognized.
Madam Speaker, I yield myself such time as I may consume.
Gentleman is recognized.
Madam Speaker, I did not think that when I came down here today to debate this one-page bill for Lawsuit Abuse Reduction Act, that it would somehow get linked with the more than 2,000-page monstrosity popularly known or unpopularly known as Obamacare, and told that somehow the promise that was made over and over and over again, that if you like the health insurance you have, you can keep it, was not the fault of the legislation itself and the people making that promise, but was rather the fault of the insurance companies who have to deal with this more than 2,000-page monstrosity and the more than 20,000 pages of regulations that have been written and have to rewrite virtually every insurance policy for health care in America because of the mandates and the regulations that are in that legislation. And somehow the more than 4 million Americans, almost all of whom are the little guys, as I've just heard referenced, are somehow, I will not yield until I'm finished with my remarks, that somehow they are, this is the fault of the insurance companies who are doing what they have been required to do under the law, and that is to make changes in the law that necessitates changing all of their policies, that necessitates making sure that things that are mandated by the law are included in their coverage, whether the people who had the policies that they liked could afford these new changes or not. So many, many Americans are forced by this legislation to seek new health insurance, in some cases far more expensive, and they can't afford it. But somehow that's made out to be the fault of the insurance companies, not the people who wrote the law, voted for the law, and then are implementing the law in spite of promises that were made that cannot be kept, not by insurance companies who are abiding by the law, but by others. Now, to compare that to this legislation, which is a one-page modest bill to assure that people who are the victims of frivolous lawsuits and fraudulent lawsuits cannot have justice in our federal judicial system, I think is just plain wrong. And the chart that has just been displayed regarding Rule 11 filings during the 1983 to 1993 period, when there was an increase in the number of hearings related to Rule 11, that's a spike for justice. That is a spike for the increased opportunity for people who have been subjected to some of the most outrageous lawsuits that were described by the gentleman from Texas, that were described in my opening remarks, and that is their opportunity to seek real justice. And that's what this bill is all about, reinstating a spike for justice for the little guy, for the small business person, the individual who finds themselves subject to a lawsuit under some of the most ridiculous circumstances you can imagine, and saying, you know what, my life has been turned upside down by this lawsuit. I'm not getting sleep at night. I'm having to spend thousands or tens of thousands or even hundreds of thousands of dollars on attorneys. I'm having to do things to change the way I live my life. And it's all because of something that was frivolous or fraudulent, and now I'm seeking to have some redress for that wrong that was done. That's the very basic principle of the American jurisprudence system, that people, when they're harmed, have the right to go to court and seek redress of their grievances. And that's exactly what this provision in this law does under Rule 11. It says that if the court finds that the lawsuit is frivolous, then there is a mandatory requirement that the individual who is the victim of that frivolous lawsuit should recover losses. That is indeed what this legislation is all about, and I'm proud to support it, and I'm happy to yield to the gentlewoman from Texas.
Well, the gentleman is very kind to yield, and very briefly, let me say it's about policy and process. The gentleman knows that most of America is very happy about the changes in the Affordable Care Act to get them out of the junk insurance policies that they have had.
Reclaiming my time, if that were the case, then I don't think the President would have unilaterally delayed the 1 year, for 1 year, the employer mandate where the vast majority of Americans receive. Imagine if this bill had taken effect as originally planned, and all of the employers in America looking at their insurance policies for their employees were also having to tell their employees that they could no longer afford to provide insurance, or they're going to provide a different plan where the employee had to pay more money, or the employee was being put into the exchanges. All of those things would be significant, serious problems. But we digress from the importance of this legislation right here, which is something that we can join together in a bipartisan way to see that we have justice in our judicial system when people are unfairly sued, unfairly subject to frivolous or fraudulent lawsuits, and I reserve the balance of my time.
The gentleman from Virginia reserves. The gentleman from
Madam
Michigan is
Speaker,
recognized.
I'm pleased to yield to the gentlelady from Texas an additional 2 minutes.
The gentlewoman from Texas is recognized for 2 minutes.
I thank the gentleman very much. Let me be very clear. I want to say to the gentleman from Virginia that I would venture to say that those attacks on frivolous lawsuits are the big guys against the little guys who had very legitimate and good intentions. It may be their resources were limited, and so they have to be subjected to a Rule 11 on a perfectly legitimate litigation to be called frivolous. The other point that I was making is that there's something between process and policy. I will stand again to say that the policy of making better health plans and better and healthy Americans is supported by all. The process that I challenge is that the big insurance companies decided to use the process of cancellation letters, not letters that said modify. They decided to use their big authority to be able to undermine a policy of lifting the boats of all Americans for good health. That's what I see Rule 11 as. I see that as undermining the basic scales of justice. It says to get back money for frivolous lawsuits. Well, the frivolous lawsuits may be on one individual or a group of small individuals who feel that they have been harmed. They may have lost. They may be in the midst of pleadings, but they don't have the resources to file a Rule 11. And so what happens is those who want to be punitive will use a Rule 11. I think a judge can make the determinations under the present system, and so the spiking that we're talking about is a spiking of Rule 11 filings. That's more litigation. That's more litigation. That's what we're suggesting that we don't want. And this respect that the President and others are giving, all of us want to give respect to the mishap that has been created by the insurance companies. And so, fine, the President is giving respect to the constituents because his bottom line is to make sure all uninsured Americans, like the 6 million in the state of Texas, get the opportunity to be insured. Let me thank the gentleman for the time, and I'll yield back. I believe that we're going down the wrong path for Rule 11, and I thank the gentleman for yielding.
The gentlewoman's time has expired. The gentleman from Michigan continues to reserve. The gentleman from Virginia is recognized.
Madam Speaker, I continue to reserve the balance.
The gentleman from Virginia reserves. The gentleman from Michigan is recognized.
Madam Speaker, it's my pleasure now to recognize the distinguished gentleman from Pennsylvania, Mr. Matthew Cartwright, for 4 minutes.
The gentleman from Pennsylvania is recognized for 4 minutes.
Thank you, Madam Speaker. Madam Speaker, I come here as a freshman in this Congress. I come from northeastern Pennsylvania. My first time involved in the political theater, and I tell you, Madam Speaker, that I have plied my entire adult life in the civil courts. I have handled all manner of civil cases on behalf of defendants, on behalf of plaintiffs, on behalf of people, on behalf of companies. I've seen the whole spectrum of civil litigation, and I've been doing that both before and after the repeal of the mandatory LARA provision in 1993. So I am as qualified as anybody in this chamber to speak to the merits of this so-called lawsuit abuse reduction bill. It's a bill that should fail, and I say this not just because it tends to shut the door further on consumers seeking justice in the court system of the United States, but because it also reinstates a rule that has already been seen to be misapplied, to be misplaced, to be a bad rule. In 1993, we abandoned this rule for a reason. It wasn't because we pulled it out of thin air, the idea to abandon this mandatory sanctions under Rule 11 rule. It's because of the experience. The gentlelady from Texas held up the chart. You saw the spiking in Rule 11 filings. That wasn't because people were out diligently cleaning up the mess in civil courts. It's because they were encouraged to make those filings because of the mandatory nature of the rule. They felt like their clients expected them to file for Rule 11 if they won a motion or if they won a case, and it led to an enormous increase in unnecessary, what we call satellite litigation. And it was the federal judges who complained at the Judicial Conference. They went to the Supreme Court. And Congress ultimately decided in its wisdom to abrogate that rule and abandoned it, because it was all of this wasteful litigation that was going on. We had a federal judge outside of Philadelphia, United States District Judge Robert Gothrop, who saw so much of that, he added a nickname to this Rule 11 litigation that people felt compelled to file. He called it zombie litigation. He called it zombie litigation, and he was enormously relieved when in 1993 this Congress did away with it. Current law allows judges to punish frivolous filings, and on occasion frivolous things happen in court, and the judges don't like them and they have the power to punish them. And it is with their discretion that they do that. We like discretion to be vested in federal judges. We're careful about selecting federal judges. We vet federal judges. We interview federal judges. We actually confirm them here on Capitol Hill to make sure that they have sound discretion and good sense. And it is best left to the sound discretion and good sense of federal judges to handle the situation when someone goes overboard with the filing. This is us here now trying to fix a problem that doesn't exist. The National Center for State Courts, make no mistake, tort cases constitute 5% of filings in civil court. It's debt collection. It's breach of contracts cases that take up 70%. From 1999 to 2008, tort case filings in state courts in the United States dropped 25%. Dropped to 2008. And this is all after the abrogation of the mandatory Rule 11 rule. So what this bill is really after is simply to make people afraid to go to court. What this bill is really after is to make people afraid to go to court to assert their rights, to assert their voting rights. I'm almost finished. To assert their voting rights, to assert their workplace safety rights, to assert the rights guaranteed them under the United States Constitution. This bill makes them afraid to go to court to assert their rights, and that's why I urge my fellow members, Madam Speaker, to vote against this bill.
Would the gentleman yield back?
Would the gentleman yield?
Yes.
I would ask the gentleman from Pennsylvania, what other sorts of legal claims should a victim be able to prove in court but be denied damages by the judge?
I'm not sure what the gentleman is referring to.
Well, you're in court, you've got a frivolous lawsuit, the court finds it's a frivolous lawsuit, you prove that you're the victim of that legal claim, and you prove it in court, and yet you can be denied damages by the judge. What other legal remedy, what other legal claim would the gentleman cite other than frivolous lawsuits filed by
the gentleman's time has expired,
where that would be the case? Are there any others?
Speaker, may I respond?
The gentleman's time has expired. If the gentleman wishes to respond, he may respond.
Mr. Speaker, I will yield myself 1 minute and be happy to yield to the gentleman to respond.
The gentleman from Virginia yields, is recognized for 1 minute.
Thank you. The answer is this. We don't have idiots as federal judges in this country. If a federal judge sees a situation where somebody is really acting egregiously, really abusing the system, really filing a frivolous case, then that federal judge just about uniformly will sanction the guilty party. We see that over and over and over. What we're doing here is imposing a cookie-cutter, one-size-fits-all remedy that the judges don't like. It adds to increased litigation, and it's unnecessary and expensive litigation. And I yield back.
Well, I thank the gentleman for his comment, and I would just point out that while I practiced law during the time that the mandatory sanctions were in place in federal court and found that it was a very good environment to do so, I was then elected to Congress and got here and found that, lo and behold, a small panel of judges changed that rule without looking at the evidence of a survey of federal judges where 751 federal judges found that an overwhelming majority.
The gentleman's time has expired.
Mr. Speaker, I yield myself such time as may consume.
The gentleman is recognized. Such time as may consume.
Thank you, Mr. Speaker. Federal judges found that an overwhelming majority of federal judges believed, based on their experience,